I'm just going to give people 1 more minute to turn up, because while we appreciate your time, we will get started on time for everyone that's turned up so far. Just pop yourselves on mute so during the presentation, so that Jay can pass over all the information. If you do have any questions, please just pop them into chat. That would be great, and we will do questions at the end. There's plenty of time for Q&A at the end. If you want to ask your question and go on microphone live, that's absolutely fine. Otherwise, I'll read out the questions at the end, and then Jay can answer them. And if you've got follow-up questions, we can do it then. I totally get not everyone wants to be on camera and not everyone wants to talk on a webinar. That's absolutely fine. If you can put your cameras on, though, it does make it easy for Jay while she's presenting to see all your lovely faces. Excellent. And I think that should be everyone's just about here now. If you've not already, pop yourself on mute. I am going to pop through and spot anyone I can who's not muted. I'm going to hand over to you, Jay, to get started.
Well, thank you, Fiona. Hi, my name is Jay, and I am here to take you through the Employment Law Update 2025. And my screen has frozen, so we're off to a good start. Give me just a second.
Nothing quite like a tech issue to get started with.
Right, here we go. Yay! What was that you were saying, Fiona, about your issues you were having with PowerPoint? Okay, so a lot of you guys will already know who we are and what we do, but for everybody who doesn't know who we are and what we do, we're Danton HR, and we help businesses reach their goals by getting the best out of their people. And we do that by providing HR support for businesses with in-house HR and without in-house HR. We also provide training and development for all kinds of businesses as well. So if there's anything employment law related, people management related, or training related, we are your go-to people. Right, let's get started. There's a lot to cover, so we will kick off as soon as my screen is unfrozen again. What is going on? Sorry about this, guys. There we go. Okay, don't do anything else, please, Microsoft Office Teams. Right, so takeaways. We'll be sharing key actions and ideas that you can take away and apply to your business today. And we'll be providing more guidance on how we can help. There will be a Q&A at the end, so if you want to pop your questions onto the chat box, we will get them covered off for you. Okay, so today is going to take approach in a 3-step approach. So we're going to recap on the changes from 2024 and the actions that employers should be on top of right now. Right now, what you should do now, so we have had a bit of a policy, a new policy actually, in terms of neonatal care that we're going to cover, and that is brand new as of April. And then what you need to have on your radar, so the proposed changes from the Employment Rights Bill and the future actions that you will need to take. Okay, so let's jump right into the recap. So what you should have already dealt with in your company, and no judgment if you haven't, we are here to help you if that's the case. Simplified holiday entitlement pay. So for any irregular hour worker or part of the year worker, we need to start paying their holiday pay differently. And the calculation is 12.07% of any hours worked. And that gives you the calculation that the 5.6 weeks minimum time off would have given you if they were a permanent or full-time employee. That came into place in April 2024, so you should have updated your contracts, your handbooks, you should have notified your payroll department, updated the pay slips, and trained any managers that might have any input to that as well. There was changes to the fines that employers were penalised with for illegal workers. So don't know if you'll remember, but the first breach would have been about £15,000, up to £15,000, and that's increased to £45,000 per illegal worker. Repeated breaches, the fines have increased from £20,000 to £60,000 per illegal worker, so it's a very expensive mistake to make. If you want to avoid any fines like that, then we advise that you audit your right to work documents, complete the day one checks as per usual, and set triggers and reminders for document expiries. And we've got some updates coming up about how we will tackle the e-visas as well. So, carers leave. So carers leave was created, and carers are now entitled to 1 week of unpaid leave per year from the day one of employment. Okay, so that covers any dependent that they might have with a long-term care need. However, they do not have to provide evidence for that eligibility. Okay, it can be taken in half days as well, and employees are allowed to request that it is deferred or delayed if it's been scheduled. So if somebody's scheduled carers leave, they are allowed to defer or delay that. Again, your tips for moving forward with that would be to update the handbooks, train your managers, make sure that they are aware of these changes and they're not going to deny any requests because they're, like they're not sure about it, and update any HR management systems that you've got in place so that they can have that leave to take. Flexible working requests. So this has been a biggie. Previously, an employee had to be with you for 26 weeks before they could request flexible working, and that's changed now to day one. So as soon as a new starter starts, they could quite well hand in a flexible working request. Employees can now make 2 requests per year, even though previously it was only 1 request per year. There's no requirement for them to explain the impact or the perceived impact on the employer, whereas previously this was always required. You don't have to do that anymore. And employers must consult with the employee before making a decision. So previously there was no requirement to consult, but that's been changed now. And instead of responding within a 3-month time period, we now have to respond within a 2-month time period. So they've shortened that time period quite significantly there. Things for you to do: update your handbook, update any forms that you use for flexible working, and ensure that your managers are trained. They know how to respond to these things. They know how to field questions, and make sure that they are informed. Moving on now to redundancy and family rights. So extra protection against redundancy for pregnant employees and through to 18 months after the birth. So that is the same for maternity, adoption and shared parental leave as well. If you were to go through a round of redundancies while somebody was on maternity leave, they would have priority status now for redeployment opportunities. And that priority status could well be in place for 2 years if the employee notifies you at 12 weeks that they are pregnant. So that's a long time. You would really have to plan ahead if you were anticipating any restructures, and encourage an open culture so that these things are discussed as soon as reasonably practical. Update your handbook, update your policies, and make sure that that is listed somewhere in there. Paternity leave has seen a big change as well. So you can now take it in single, non-consecutive blocks of 2. So before it was a single block and you would lose the first week the second week if you didn't take it with week 1. That's done now, so it can be used at any time up to the end of the first year after childbirth, so until the child reaches 1, or adoption. And previously it was 56 days, but that's now been extended, and you can take 1 week here, 1 week there. It's very flexible. So ensure that your policies reflect that change. Update your handbooks, let your managers know, and yeah, if any questions come in, they know how to answer them. Tipping. I don't know if we've got anybody here in the hospitality industry, but if we do, then you will be aware by now that tipping has changed quite drastically. So the main changes are employers are banned from keeping tips or making unfair deductions. Tips must be distributed in a way that is clear, objective, fair, and reasonable. If tips are allocated based on factors like seniority or length of service, that must be clearly explained and documented. Distribution must be equitable to all eligible workers. Doesn't mean it has to be equal, but they have to be reasonably equitable. Employers must have a written tipping policy. So when this came out, we spent a long time going through tipping policies for our clients. And that has to be made available for staff. Usually it would be in the handbook or something. Workers do have the right to request information about the value of their own tips. So if they need a breakdown of how many tips that they have received over a course of a year or something, then they have got that right to see that. But they can't see the tips that other people have earned. Tips must be paid out by the end of the following month at the absolute latest. And there's new tribunal claims to be introduced for failing to allocate tips fairly or not passing on all tips to the staff. So some quite big changes there. And like our advice is to create a policy if you haven't already got one, communicate the approach, make sure that it is transparent with the employees, and train your managers as well. So you'll see a thread of training managers, because they are obviously frontline for employee relation issues like these. And another big one that if you've worked with me before with the sexual harassment updates, you'll know all about this. But there's new rules around the prevention of sexual harassment in the workplace. So there's a new proactive duty for employers to take reasonable steps to prevent sexual harassment in the workplace. And that means that they're doing more to show employees what is and what isn't acceptable behaviour. Obviously, you can't control somebody 24/7, but in order for the employer to not be liable for any sexual harassment in the workplace, we have to follow certain steps and evidence certain things. So things to do would be update your handbook, complete a risk assessment if you haven't already, and develop an action plan for any risks that have been identified. Employees need a bit of training, but managers need a lot of training in regards to this subject. So if there's anything that you guys need, or if you've not got anything by way of prevention of sexual harassment, then please let us know. Tribunals have now uplifted their compensation by up to 25% where an employer is found to have breached this duty. So it is an important one, and this can get very expensive very fast. E-visas, so I touched upon this earlier. The UK is moving to a fully digital border and immigration system. So e-visas will soon replace physical documents like biometric residence permits, cards, passports, stamps, and vignettes. Many employees already have digital proof and use a share code to prove their right to work, and I'm sure a lot of you have already seen these or used that system, and that's how it's going to go. If you've got any employees that have expiring physical documents, they now need to obtain digital proof. And employers will use the share code system to check status via the Home Office portal. So there has been some delays due to technical issues around this. However, this was meant to be happening in February. However, as it's been delayed, we will keep you updated with any changes to that. So actions for employers: contact affected employees and check that they have registered on the UKVI system. Obtain share codes and check their digital e-visas for anybody who doesn't have that check already in place. And ensure your record keeping is correct. And please remember to set reminders. If you've got an HR system, there should be an option there to ping you a little reminder when people are coming up for expiry. Moving on to gender pay gap reporting. So the government plans to strengthen gender pay gap reporting requirements, and that is going to include outsourced workers, not just direct employees. That means that organisations could be required to account for pay disparities among workers delivering services on their behalf, even if they're employed by third parties. So you're looking at agency workers, temp workers, contractors coming in on a service-based agreement, everybody. And if you do report on your gender pay gap, what we would advise you to do is to update your handbook, review your inductions, conduct risk assessments and put action plans in place, train your employees, and regular refresher training on how to deal with our staff and make sure that their pay is, falling in line. And I'm sure you're already aware of the national living wage and national minimum wage, so I'm not going to read this whole table out, but just make sure your pay is correct. If you've got anybody on the minimum wages, make sure that they've all been uplifted. Write to any affected employees to let them know that they have been they've received a pay increase. Review any pay differentials and impact across other parts of the business. So does this close any gaps that should remain quite, spacious? Don't know. That just have a wee look and make sure that any gaps are considered. And budget for the changes. Yeah, so I mean, all of this should have been done by now, hopefully, but if not, let us know and we can help you. So right now, the changes that have came in place in April, along with the wage increases and the statutory pay increases, I should say, is a little change to the family leave group of policies, and this is neonatal care leave. So if you haven't got this already, we do have a package that we can help you with, which Fiona will talk about more towards the end. So the changes that are being implemented are that all employees are now entitled to up to 12 weeks of neonatal care if their baby requires medical care shortly after birth. Statutory neonatal care will be available to eligible employees as well, and it's structured in 2 tiers depending on when the child receives this care. During this leave, employees are protected from dismissal or redundancy, and all terms and conditions of employment continue, including the accrual of annual leave. So that's a good one to remember. What we need you to do is update your handbook with the new policies. Make sure that any other family policies refer to this new policy as well, and just let your managers know about the changes and what this means for employees in the team. Okay. So now we move on to what's on the radar, which is exciting stuff. The Employment Rights Bill 2024 was introduced on the 10th of October within 100 days. The aim is to grow the economy, raise living standards across the country, and create opportunities for all. So this is progressing well through Parliament, and amendments are taking place following consultation with business groups and trade unions. Any amendments that are made, we will keep you updated with, so make sure you've opted in to receive our email updates. The bill will support the government's mission to increase productivity and create the right conditions for long-term, sustainable, inclusive and secure economic growth. It will help raise living standards across the country and provide better support for these businesses who are engaged in good practices. And they'll focus mainly on enhancing rights, pay, time off, contracts, equality and harassment. Okay, so we have had a lot of employers be a bit uneasy about these changes. Remember, they are not set in stone yet. They are still going through amendments. And that feedback has definitely reached the Labour government. We have had everything going through, focus groups with employer groups, trade unions. So it's all very much up for discussion, but we will give you this information as we know it just now. So what's on the radar? They're definitely going to be enhancing existing rights, okay? The plan is the ordinary unfair dismissal protection is going to be a day one right, okay? But the saving grace is statutory probationary periods will still apply. So if somebody starts and they're on probation, the probation can be failed and the unfair dismissal protection won't be applicable. Okay, so our future actions for employers and our advice to you would be to review your onboard and induction processes, make sure they're watertight, ensure that probationary periods are in contracts and managed effectively. No longer will we be able to just let people coast along probations and then deal with them afterwards. Review the handbooks, probationary periods, disciplinary procedures, dismissals, make sure that everything is looking perfect. Fire and hire dismissals. Okay, so right now, we would be able to fire and hire people on a different contract if they refuse to have that contract changed. This practice is going to be brought to an end. So other than evidenced major financial detriment and unavoidable business reasons, you will not be able to do this. And this is going to come into play in October 2026. It's going to be automatically unfair to fire and rehire somebody on different terms. The future actions for employers would be to avoid at all costs. However, if it is genuinely unavoidable and your business is going through major changes, financial difficulties, then the key is to create and evidence sound business cases and only where applicable. And I would not be doing this without advice from either us or an employment lawyer. That sounded a bit scary, but it is a very serious one. Special protections during redundancy for pregnant employees. So back onto this, these are going to be extended to other dismissal types, not just redundancy. So we do expect to see that coming up as well. We advise you to approach any change with caution, carry out equality impact assessments of any proposed change, meaningful consultations with individuals, and again, train your managers, make sure they're up to date with all of this stuff as well, because it just takes them to say the wrong thing, do the wrong thing, and you will land in hot water. Trade union reform. So as expected, the Labour government are going to be really hot on this now. We are expecting to see minimum service levels during strikes to be abolished. They'll have greater access to workplaces for recruitment, organising, collective bargaining, stronger legal protections for union representatives, including time off for union and equality-related duties, and simplified union recognition processes, so removing complex thresholds and making it easier for unions to gain formal recognition within companies. We will let you know if and when that is implemented and what to do. Collective redundancy procedures to be extended, so it's going to include additional triggers for collective consultation. The threshold is going to remain the same, so 20 or more employees redundant at a single establishment within a 90-day period. But the new provision is going to require consultation when redundancies come across multiple establishments, reach a certain number, and then it'll be specified and more regulations coming up. So again, if you were planning mass redundancies, just approach with caution. And come to us for help, and we will make sure that you do everything correctly. The new Fair Work Agency is a new one as well. So the Employment Rights Bill has proposed the establishment of a single enforcement body. This is likely going to be named the Fair Work Agency. Now, they are going to oversee and enforce various employment rights. So it's not going to be just a case of an employee raising something when something isn't right. This Fair Work Agency is going to be enforcing these changes. It's going to have the authority to regulate employment agencies and businesses, and it will implement a penalty scheme for any unpaid employment tribunal awards. It's going to enforce compliance with national minimum wage, statutory sick pay, and holiday pay. So this probably isn't going to impact a lot of our clients because we know that they're doing everything correctly. But for those who are maybe flying under the radar, cutting corners here and there, it's going to be a fright for them. So we'll keep you updated with that. I'm quite excited to see how that one turns out. Pay, moving on to the upcoming changes in pay. So they are looking to change statutory sick pay, and this is going to start being paid from the first day of the absence. So you will no longer have to wait until you're 4 days in. You'll be able to get SSP from day 1 of absence. It's also going to remove the lower earnings limit. So it will be paid either percentage-wise of weekly pay or £118.75, which is the statutory sick pay rate just now, whichever is lower. So what you will have to do when that comes into force is to update your contracts, your handbooks, make sure that your absence management procedures are on point. Make sure your return to work meetings are being held and they are valuable conversations. Make sure you're monitoring the sickness absence within your company, and make sure your managers are aware of these changes too. Back to tipping law again. So we're expecting to see strengthened requirements on consultations when developing or revising tipping policy. So you're going to have to speak to your staff, make sure the policy is working for them and that they agree. And again, we're going to go back to gender pay gaps. So large employers will be required to create equality action plans on addressing any gender pay gaps that might be visible within their company. And if you're a smaller employer, then you can choose to report on the gender pay gap as well. So whereas before it was strictly only 250 employees or more, smaller companies may decide to do that. And if you do decide to do that, it's important to do the pay analysis, a creation of action plans, pay reviews and salary benchmarking so that you know where you fall in that gender pay gap. The changes to time off upcoming are the right to unpaid bereavement leave from day 1. So we're expecting that to look similar to parental bereavement leave, which came into play a wee while ago. So from day 1 of somebody's employment, if they suffer a bereavement, they will be able to take unpaid bereavement leave. So you likely have some sort of bereavement leave already in your policies and handbooks, but any changes to that would need updated, and you would need to obviously inform your managers. Unpaid parental leave currently needs to have a 12-month service for employees. However, they are looking to change this so that it is a day 1 right as well. So again, That includes an update to the handbooks and policies. You need to inform your managers and make sure that everybody is aware. And currently, you have to work at a company for at least 26 weeks to be eligible for paternity leave. We're expecting to see that to change as well from to a day one right. And it may be that they will also allow this to be used after shared parental leave and pay, if that is applicable to the employee. So again, we would just update our handbooks and let the managers know of the changes. And more changes to flexible working, which has already changed quite drastically since this time last year. But when refusing flexible working, new requirements to explain the grounds on which you've denied the request is expected to come in as well. So just be aware of that. It's not going to be a simple case of just denying a request because it doesn't work for the business. We have to really find a decent explanation. So we advise you to revisit your flexible working policies, review hybrid and general flexible working that you have got already in place, and let your team leaders, your managers know. And contracts. Contracts are slightly going to change as well. So again, trade unions are going to be promoted, and we will expect to see a statement in employment contracts, something like you have the right to join an employment, a trade union, something along those lines. And then employers are expected to regularly remind employees of their right to join a trade union thereafter. So again, we will keep you updated with this, but we would expect to be updating contracts when that comes into play and to build a process to ensure regular reminders are in place. 0-hour contracts as well. So we're getting more rights around 0-hour contracts. The government doesn't like them, and I can see us just not being able to use them soon. However, we are expecting to see the following changes. So 0-hour workers should be able to get reasonable notice of shifts and changes to their shifts. If shifts get cancelled short notice, we are expected to see compensation going to those employees. And if the 0-hour employees have been working regular hours for a period of about 12 weeks, then we're going to have to start offering them guaranteed hours. So yeah, definitely changes to make employers avoid using 0-hour contracts. But if you do use 0-hour contracts, we will keep you updated. But we would expect to be updating the contracts, updating the handbooks, and reviewing existing practice and potential financial implications to that, because obviously that will impact employers quite a bit. There we go. So other proposals alongside the bill are the right to disconnect. I'm not sure if anybody's heard about that one, but there will be an employment right to disconnect after their working shift. Supporting workers with terminal illness through the Dying to Work Charter. Extending pay gap reporting to ethnicity and disability for employers with more than 250 staff and measures on equal pay. Extending equal pay rights to protect workers suffering from discrimination on the basis of race or disability. So that's all that means. Developing menopause guidance for employers and employees on health and well-being. So menopause policy has massively exploded over the past couple of years, rightfully so, and we're going to keep going along that path with menopause as well. And they're looking to modernise health and safety guidance, so that'll be a fun one too. Lots of changes. We will keep you updated. So if you have identified any gaps that you might have just now, make changes, speak to us. We can help you try and fill those gaps as best as you can. In terms of all of the stuff that should be on your radar, don't feel like you have to rush to make changes, but feel free to start planning now for the future. We will keep you updated with any amendments that continue to go on, but things like, you know, day one rights for employees, just make sure your recruitment, your onboarding, induction and probationary period are all up to date and they work for the business. Ensure effective communication across your business as well. So when these changes do come into play, make sure you've got a platform that you can share those changes with your management team. And provide support for your managers. Like, I mean, my voice is going because there's so many changes coming up. It's just like talk, 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 talk. Just make sure that your managers feel supported. It's a funny time with change, you know, it's really important that they have got a platform to be able to learn about the changes, to discuss the changes, and to ask questions, no matter how, like silly they are, or yeah, they might think it seems obvious to others, but they need to be able to ask those questions and get their confidence up. Okay. Right, well, thank you for listening. Fiona, I will hand over to you just to do the close off and then we'll have questions.
Brilliant, Jay. There were so many changes in that. It must feel quite
too many.
overwhelming for business owners at the moment. But look, Danson wants to help you, and we do have some ways that we can help through our HR support. So you'll have seen on that checklist, Jay had, update your handbooks and, check that your contracts are right. So we can help with the updated handbooks and we can help with employment pacts if you do not have them in place already or they need updating. We're going to send you an email after this session to let you know how you can buy any handbook updates or employment packs that you might need, or just come and ask like Jay if you have questions about whether or not they need updating. One of the big changes was the changes to neonatal care. So what we've put together is a package that gives you like 30 minutes of training, including the neonatal policy and a chance to ask questions at the end. It'll run much like today. And, if you've got employees who are starting families or likely to start families, you never know what might happen. And these things, they're very stressful. They happen at the last minute. It's an emotional roller coaster. So just having that in place just in case is really important. So again, we'll send an email after this giving you the full details, but do get in touch with Jay or anyone else from the Danson team, or just reply to one of the emails we sent this morning reminding you of like the links and everything. The other thing that Jay mentioned quite a bit was training your managers. Now we have a new cohort of Managing People Fundamentals starting later this year. If your managers have not had any formal training, hugely recommend this because it means they are better placed to protect your business from all of these employment law changes, plus the ones that are coming up, and so much more within your business. I can send out more information on this. We've had the people we've put through so far. It's been transformative for the business. So do get in touch about that. And finally, we have individual training days that we can put together for you guys. Preventing sexual harassment in the workplace is incredibly important. That new duty has come in, and we've got a training page where you can go in and just sort of, if you've got areas that you identify after listening to this update that need troubleshooting, we can help you find the best training that just focuses on those areas. So that's enough of my little sales patter at the end. I hope you've enjoyed it. We're ready to take any questions. So if anyone has one, please put one in the chat. But I know how much people hate going first if you've got a question. So we had one that popped up last time we ran this event in person, and I think it's kind of, probably how many people might be feeling, is how do we get rid of people if they're protected from day one and they're just not right for the job? So Jay, I don't know if you wanted to start with that one. If anyone else has any questions, pop them in the chat.
Yeah, so this question came up quite a bit actually when we've been delivering this update, and the answer is probationary periods are going to be your friend. So we would strongly advise that if your probationary period is anything less than 6 months, it really needs to be reviewed. So we would be advising people to start implementing 6-month probationary periods, if not maybe 9 months, with the option of extension. And that will give you a very good window to make sure that that employee is right for you, right for the company, and right for the job, basically. Probationary processes need to be structured a lot better than they currently are for a lot of people. It's not just right, welcome to the company, I'll see you in 3 months for your probationary end of probationary meeting. It should be consistent. There should be regular updates, regular feedback, so that nothing is going to be a surprise to the employee if it doesn't work out. But yeah, so the overall advice is to extend probationary periods and ensure that the whole process is working for the business, because that is only going to be, it is going to be your only sort of saving grace really when this comes into play. Is there any more questions?
There's none come through from the chat so far, Raya. I'm just checking no one sent you a DM. Oh, we've got Mark popping a question in. So give you a chance. I mean, you've covered so much today, Jay, as well.
Everyone's ears are going to be bleeding now. I'm sorry.
Max asked, will UKVI replace passports then?
Not for, only for international people. So if you have a British citizen, you can still take their passports as proof of ID. This is only for immigration purposes and right to work.
Mark, if it helps you want to come off of mute, you're more than welcome to.
I'll stop sharing my screen so I can see everything. Any more for any more?
No more has popped through. Look, if you've got a question and we haven't answered, Jay hasn't answered it today, like I've answered your questions. If you've got a question and Jay hasn't answered it today, please do just pop an email in, send Jay a link on direct message on LinkedIn. Raya has put Jay's email address in the chat there. And again, just message Jay if you have any questions about how we can help you as well. But otherwise, I do want to say thank you so much for your time today. It's much appreciated. I hope you all got lots out of it, and we'll let you know when the next event is. Jay?
Thank you. Yes, very happy to take your questions out with this forum if you need them. But otherwise, thanks so much. Thanks, Mark. Right, okay, well.